I also just wanted to remind everyone, this is not a 2025 update, but it was a big update for 2024, and that is the PAGA reform that was signed into law mid-year. So the main takeaway really, I mean, it's a lot of detail on the PAGA side. A lot of it deals with litigation. As an attorney, it's, things that I need to know. But on the employer side, the main takeaway is one, you have the ability to reduce your PAGA penalties by 15 or 30% if one, you take efforts to proactively comply with the labor code before receiving a PAGA notice. So this is a perfect time if you haven't done it already, do your audits, review your pay practices, review your wage and hour, practices, review your classification of employees, because just being able to show the efforts that you made and if you made any changes where you conducted an internal audit, that can help significantly in reducing your potential exposure to PAGA penalties if you do get a notice. And the other thing is, if you do receive a PAGA notice, in the past, it's very rare that employers would go through the process of trying to cure any of the claim categories. There were only categories that you could cure, and the cost was extensive. But now the cost benefit has increased significantly. Benefit has increased significantly compared to the cost because you could have your penalties reduced if you do, quickly fix the policies and practices contained in the PAGA notice. And then there are a broad category of violations for which you could cure and, potentially get those claims out of litigation entirely if you are able to cure and make your employees whole. So that, just a reminder, there really is a big benefit to conducting an internal audit at this time because of the PAGA reform.
Andrew, can you explain what PAGA is?
Oh, sure. So PAGA is it's called the Private Attorney General Act, and it allows an employee to step into the place of the labor commissioner, essentially, to prosecute labor code violations on behalf of themselves and other employees. Now, it used to be on behalf of themselves and other employees, regardless of whether the other employees suffered the same violations that the PAGA representative suffers. But with the reform, now the representative employee, for example, if the employee claims that they suffered meal break and rest break violations, and that's it, they can't also prosecute for overtime violations, failure to reimburse, and everything else that other employees may have suffered. So it reduces the scope significantly, but it's like class action light, except it's mainly just for penalties and it just has a 1-year statute of limitations.